I'm joined by my colleagues, Rick Matthews and Drew Shores. For over 20 years, Rick has concentrated his practice on intellectual property matters, including patent, trademark, copyright, trade secret, licensing, and related litigation. He represents companies in all varieties of IP matters, including litigation in over 45 states, licensing, patent, and trademark protection, in addition to opinion and M&A matters. Drew focuses his practice on IP matters with a particular emphasis on electrical and software patent prosecution, counseling, and litigation. Drew's practice also focuses on trademark prosecution and litigation, and he has extensive experience working with both patent and trademark examiners, as well as practicing before the Patent Trial and Appeal Board, the Trademark Trial and Appeal Board, and in multiple federal district courts. Welcome, Rick and Drew. The floor is yours.
Thank you, Amish. So hello, everyone. We're about to bring up the slides here. But before I do, I kind of want to just give an overview of some of the topics we're going to be covering. It's going to be light, given the hour time frame we've got. Drew and I could probably spend many hours on these topics, and we do, frankly, day in and day out. But some of this is at least intended to be a high-level overview, so it may be a little basic for some of you, but we hope at least that you can take some nuggets of value out from the presentation. So let's see if we've got our presentation screen up yet. Oh, here we do. All right. So Drew and I are going to cover all the main topics of intellectual property. There are more than what is listed, but patents, trademarks, copyrights, and trade secrets are the principal topics we'll cover today. There's obviously other areas of law that fall within the broad scope of intellectual property law, which is our focus and practice. But at the end of the day, the intellectual property practice covers intangible rights, thoughts, creations, works of art, anything that sort of can be created or invented or reduced to practice that provides some value. So obviously, being the bigger topic, we will start with patents first, and generally go through sort of a history of patent law, its importance to innovation in this country and frankly worldwide. We'll cover some of the application, the various applications that can be filed for patent protection with a focus on provisional patent applications. We'll touch on some of the common pitfalls that we see and then give a case example for a patent case that we will go through. But generally speaking, a patent is a government grant, and it gives the holder the right to exclude others from making, using, or selling, or offering to sell or importing the invention. It's not a grant to make or use or sell the invention. That's a common misnomer. So you may have the greatest invention since sliced bread, but if someone has a more genus invention that covers your more detailed specification, then you may not be entitled to practice your own invention. You may be able to exclude others, but the patent grant doesn't permit you to practice the invention. And that's a misconception that a lot of people have. But it's a constitutional grant. Article 1, Section 8, Clause 8 of the U.S. Constitution provides, the power to Congress to create and promote the progress of science and useful arts. So it's securing for limited times, and that's an important piece, to authors and inventors the right to, exclude others from their respective writings or discoveries. And the first commissioner of patents was Thomas Jefferson, who in his own name had a number of inventions. There are pros and cons to pursuing patent protection, and we'll touch on a little bit of those distinctions today, at least during this hour. with, why you might want to pursue patent protection over the alternative, maybe being, a trade secret or keeping something confidential. And with software, we talk a lot about copyright protection as well. So there's elements to consider at each stage of, the R&D process through development and deciding whether to proceed with a patent application or not. So the patent term is currently 20 years from the filing date, the original filing date. We can compare that with a copyright that is also a limited term. Again, both copyright and patent derive from that Article 1, Section 8 of the Constitution. And so it provides for limited rights. And the limited rights, in one respect, is the time frame. So 20 years for a patent, 70 years after the death of the author for copyright. And trademarks sort of stand on their own. They're a more of a commercial aspect. Given that companies will use their names perpetually, there is no limit on the time for trademark protection. So again, patent applications, we're looking at inventions, new developments, technologies that have some utility. Copyright protection, we're looking at works of art, artistic works, manuals, or any literary or musical or video, the like, anything that can be reduced to a tangible medium. And then trademarks are just that, sort of the branding or the marks that companies use to distinguish themselves or their goods and services. So moving on, at least early on in our patent system, Charles Duell, the Commissioner of Patents in 1899, wrote that everything that can be invented has been invented. Obviously, this is the tail end of the Spanish-American War. The U.S. is getting its feet under it. I mean, at this time, the same year, Ellis Island is recognized as part of New York. I mean, it's very, very early in the country, but yet lots of developments. And at that time, there were over 600,000 patents issued. Today, we're well over the 11 million mark. So while Mr. Duell may have thought that his role as commissioners of patents would be a short-lived one and would eventually go by the wayside, there has been, as everyone on this video should recognize, quite a bit of development, and there continues to be. So we're at over 11 million in the patent numbers past May of 2021. So why would anyone want to obtain a patent? The first, as I alluded to earlier, reason is to exclude others from practicing that invention. There are other reasons, good reasons, force competitors to design around the technology described in the patent, defined in the patent. There may be opportunities for licensing or collecting royalties based upon that technology. There's also opportunities to cross-license where you may be the unfortunate recipient of a lawsuit and you're a defendant trying to negotiate your way out. But frankly, and what we've seen quite a bit and growing over the years is the private equity and other investment in companies that see the value in having patent protection. It's a more easily tangible form of protection where trade secrets, as we will get into later, require that you keep those secrets, just that, secrets. So the patent system works just the opposite. Its goal is to publish to the world the invention. So there's nothing left to keep secret. But this tool has its positives, obviously creating innovation, but there's also reasons why you may not want to, given that you're disclosing to the public in a patent application how to make and use the invention. There's no longer an opportunity to keep it secret. So there's always a critical juncture at the time of deciding whether to proceed with a patent or keep whatever the technology is as a trade secret, because you're really trying to decide, can we keep it secret? Is it more valuable if we kept it secret? Is it a formula or process, a secret sauce that if we let the cat out of the bag, then the world will know? But that's the way the patent system works, is you have to let the cat out of the bag. You have to disclose fully and completely the invention sufficient for another person to recreate it. So The reasons why you wouldn't pursue patent protection and gain that 20-year government monopoly is if it's not patentable, for one. And we run into those issues all the time. We do patent searches and we try to assess patentability on, inventions that come in our doors day in and day out. There's other, it's not just an on or off switch either, though. So patentability may be there, but it may be so narrow, given what we found in our search or, what's out in the field, that it's not worth patent protection. And we run into that as well. So it becomes less of a legal decision and more of a business decision in a lot of respects. And then the last one, as I sort of alluded to, maintaining the technology as a trade secret is very valuable because there's no timeline. There's no limits on the timeline to keep a trade secret. Coca-Cola formula is one famous example. So as long as it can be kept secret and there's value in keeping that secret, then trade secret may be the best option. And it's certainly cheaper than getting patent protection. So there are certain requirements. Once the decision is made to proceed with filing a patent application, the next step, if you will, is to look at all the elements that are required, and they're statutorily based. And while the law has evolved quite a bit over the years, they've generally been the requirements have been pretty static. You have to have utility, and that means it's got to perform some functional benefit. It's got to be something that is not a law of nature or a naturally occurring phenomenon. It has to have its own sort of standalone utility, and we also broadly define that as subject matter. You also have to have novelty, which is another way of describing it's got to be new. You can't go patent something that was used by someone else in another context unless that use is distinguishable. And there's obviously quite a bit of details that you have to peel apart to understand whether something's patentable. But novelty sort of focuses on, the exact same thing out there in the field. Obviousness looks at a broad encompassing field of art and takes multiple sort of references together and considers whether it would have been obvious to a person of skill in the art to recreate the invention. And I'll get into these, or we will get into these here shortly. But the last three that I've listed, written description, best mode, and enablement, those are sort of the technical elements that you have to meet when preparing and filing a patent application. You have to give sufficient written description. It's got to define the invention. You have to disclose the best mode, even though that's not a fatal requirement in any law anymore. The law has changed on that issue. And then finally, you have to enable that person, that equal-minded person of skill in the art, as we call them, or the technical person that could recreate this invention. You have to give them enough details to enable them to recreate this invention. So going back to the...
We do our polling question here, Rick.
Okay. Let's see. Oh, yes. All right. So first polling question of the day. And again, this is very important for all of the attorneys seeking CLE credit. Patent number 10 million was issued in June of 2018, and patent 11 million was issued in 2021. What is the most recent patent number that issued yesterday? And obviously this is an interesting poll and guess, but we've got a few weighing in. Let's give them some time. Drew, do you know the answer to this off the top of your head?
I do. I looked it up yesterday.
All right, very good.
I had to go find the answer, and it was a number that surprised me. I'll also note, though, that when it rolled to 10 million a few years ago, I won the office pool on what date that would issue, and all those.
That's
still,
right.
Still wearing that crown, which is nice.
I do remember that. That's right. Fantastic. All right, we've got 49 of 51. We're about ready to close the poll.
A lot of folks went with B, thinking we'd rolled to 12 million. We hadn't gotten there yet. Correct answer is actually C. Patent number 11576-291 issued late yesterday evening. actually with a remarkable number. Every Tuesday they come out, so they got a whole batch of them come out yesterday. But that's the latest, greatest utility patent as of yesterday.
So almost at 12 million.
Very
We
close.
need another office poll to predict the 12 million mark.
I think so.
All right. Well, Drew, you want to take over?
Yep. Let's see here. Do we share these?
You should have access here.
Yeah, we're good. Just making sure. All right, so I hope everyone can see that. So we're gonna talk more specifically and dive in on exactly what you need and all the requirements are for a patent. Rick went over them at a high level. We're gonna dive in a little bit. And first is subject matter. So the exemplary subject matter you can have, the first is a product or an apparatus. And what is a product or an apparatus? Well, it's a product that you manufacture. These are the things you hold in your hand. The chip in the iPhone or other type of phone in your pocket, the standing desk you may be sitting or standing at right now, anything that you can kind of hold and touch. It can be, like I said, the iPhone itself, where it's a high level product, or it can be a very tiny piece of the product, where a component or a subassembly. So again, there's been a lot of litigation on stuff that's inside an iPhone or a specific gear mechanism in a machine that may only be a very small part of it, but the patent is directed to the whole. It can be on product packaging. If you get a lot of packages at like your house, like I do, I've seen some pretty innovative cardboard box designs coming in lately. Believe it or not, those are patentable if they're novel and non-obvious and the other requirements are met. Neat ways to fold a box together, use cardboard as packaging, something like that. And then of course, a manufacturing machine or component, the machine that does the manufacturing itself, or again, a small component. Any of these things can apply. Then you got processes and methods, a whole other flavor of utility patents. These are chemical processes, manufacturing methods. So you can do a claim that's directed to certain steps that are, when applied, produce a product. You have a method of using a product. You'll see method claims often mixed in with apparatus claims or a system claim, where you claim an apparatus or system, and then you have a whole separate set of patent claims directed to a method of using it. Different advantages for doing that, but you can see them. Software patents made a lot of news in the last decade or so, particularly back in the late aughts, I guess, around the 2010, 2012 timeframe. There are a lot of patents directed to business methods or software algorithms. Big debate about whether those are patentable. Some are, some aren't. We won't go that deep on whether or not they are, but just know that at bottom, an algorithm is a method. It is a process. And if it's new and novel and not obvious, there oftentimes can be patented. Compositions of matter. This is the pharma world, chemical compounds, where you're bringing things together. And these can be combinations of things, you know, at the end of the day, a lot of times you're claiming a molecule, right? It's going to be made up of things found in nature, but not the whole molecule itself isn't necessarily. You know, the new pill, the new drug has been formulated specifically to treat a certain disease. That novel compound and all the work that went into it can be protected. And that's one that you want to protect, because it can often be easy, you know, with the right equipment to break down what is inside the new drug and easily genericize it and copy it. Drug companies obviously don't want to do that. So again, we have these questions about what are patentable, improvements to known products. So a lot of the patent system is designed to facilitate this further innovation as we go on. There may be a patent on some product that's been out for a while. People noodle on it, figure out a way to do it better. That known improvement that you figure out, it might be separately patentable and give you protection there. You can do new use of known items. So this is, again, we see this in the pharmaceutical industry with patents for similar molecules, but to do different treatment methods or different treatment applications can extend the patent life of different drugs. And you can do that in any different kind of context if you have a new use that wasn't obviously known. And then a new combination of known elements. This is the fun Thomas Edison quote, where you can take a pile of junk, things laying around, things that are known. If you figure out a way to put it together in a new way, you might just have something patentable there. All right. So we said there had to be subject matter and there had to also be utility. And the only point I want to make here is utility is a very, very low bar. It has to be a new and useful invention. It comes straight from the Patent Act itself. But what does useful mean? It means basically anything, and it doesn't necessarily have to be something that anybody would want to go out and purchase. And we have some fun examples here. It's hard to decipher from this image, but what this actually is, I think the title of it is an apparatus for signaling from the grave. So just in case they bury you alive, there is a product out there that somebody patented that you could, hit the button and alert people that you're put in the ground too early. The toy saddle adapted to be carried by an adult person. This is an actual patent that was issued. That's literally just a saddle, which obviously was known in the time, but this one's adapted to ride on a person, which is obviously something people weren't doing all that often. They got a patent. This is the apparatus for simulating a high five. I actually keep one in my office to keep my morale up around here, keep things happy. Give myself a high five on multiple times a day. It just sits here right next to my desk. We also have the user-operated amusement apparatus for kicking the user's buttocks. Rick actually has one of these in his office. I'm not sure what he uses it for, but he talks about it often. And then this device, I actually had to go pull this patent and figure out what it was. In the event that you don't want to bow to somebody and take off your hat, this device will do it for you, where it'll lift it off your head and mimic the bowing to somebody you would want to bow to. Obviously something that's very important for everyone to have in their closet. All right. So novelty. This is the more reasonable requirement that we think of when we think about patent. Can't patent something that's already invented, right? So it needs to be new and novel. Cannot have it already existed in identical form. Well, what does that mean? When looking at novelty, we're looking at maybe, is it disclosed in another patent already? That's where patent examiners like to go. Is it something that's already been invented? This is where people who are accused of patent infringement like to go. They look at the competing landscape and say, well, that product's already been out in the market. Heck, we copied it from somebody else. Well, if that's the case, and we can go find that product and prove it existed before the patent was filed, then yeah, it's not novel. It already existed out in the space. It can also be something, it doesn't matter how well known it is. All that's required is that it has been known. So the kind of law school example on novelty is the PhD thesis that existed only in physical form, only in an obscure shelf of a German library. And somehow a person accused of patent infringement found it and was able to rely on that PhD that you couldn't find online, you couldn't find any other way, but it disclosed the invention at issue. And sure enough, it was not novel, and therefore the patent was invalid and unenforceable. So you got to be able to show and prove ultimately that it is novel. In the US, this gets a little trickier because there's a 1-year bar, and we're going to talk more about that. But we're, again, looking to make sure that it's not disclosed in public in the claimed form. So the claimed invention that's ultimately you're trying to patent can't be disclosed in public for more than a year before the filing date. Can't be any sale, can't be any offer for sale of the product, can't be any patent or publication, no public use, no knowledge, no prior invention by another. Let's talk more about the kind of 1-year bar and things about when you can disclose. In the US, and only in the US, you can disclose an invention. You could sell it, you could offer it for sale, and then later file a patent application to protect it. As long as you file that application within a year, you're not going to be precluded just because you told people about it. There are a whole pile of reasons that we beg clients not to do this and file first. But just know that this is something you can do. So if the engineering team has gone to a conference and presented it, it's not necessarily the end of the world. But it's obviously best practice to file the patent application first. You can also make confidential disclosures. So consider the situation where you're doing joint development with somebody, or you need to test as you develop your product. You haven't disclosed it to anybody, but you're technically going to have to disclose it to some partner or somebody that you need to disclose it to for testing purposes. You can do that, but you need to have your non-disclosure agreements in place, ensure that it's all done confidentially, and make sure that that disclosure isn't considered public in the eyes of the law. critically, I don't know if I can say all, but almost many countries require absolute novelty. So what does that mean? If you have any intentions of filing abroad or filing in other countries because you want to seek patent protection outside of the US, disclosing your invention at that conference or publishing about it or offering it for sale in the US, while you may be able to get a patent in the US, may preclude you from patent protection in those other countries because their absolute novelty requirement hasn't been met. So again, if you have any type of any reason why your products or your patents might need to be extended into foreign countries, you can absolutely do that, but need to be even more aware of this public disclosure requirement, making sure that the details of that invention aren't made known to others. So I think now, yeah, it's time for our second poll. So in line with that, consider that we all work for an international company and our engineering team has come up with a new invention that the company would love to sell throughout the world. Which is the better patent strategy? You only get to pick one. You want to rely on the 1-year grace period in the United States or file patent applications first, then start selling to others? Now, I beat this drum pretty hard for the last few slides, but what do we think the better strategy would be if you're asking a patent attorney? Got 78 participating. I got some other folks still clicking in. I know what Rick's answer would be. All right, 98. That's pretty good. Let's end it there. Yeah, so we got 43 out of 50, 86% say file the patent applications first. Yes, that's the safest way to go. You can always talk to your patent attorneys about whether there's some reason you might not want to file first. But 9 times out of 10, I gotta tell you, they're probably gonna try to talk you out of it. So
Yeah, so not only are you avoiding disclosure of your invention before it's necessary, you're not foreclosing your ability to get international protection, which is the real critical issue here for a lot of companies that are global in their products and services. At the end of the day, you have to file before any disclosure to keep and secure foreign patent protection. Absent that 1-year grace period that Drew spoke of only applies to the US. And that may be great if that's your only desire, but it does limit, any rights outside of the US, and you may not realize that that's a problem at the outset. So shifting gears and moving past utility and novelty, one of the next requirements is obviousness. So the invention cannot be non-obvious to a person of skill in the art based upon one or more prior art items. Now, we describe prior art as anything that existed prior, and Drew did a great explanation of what that might cover, including obscure disclosures in a hidden library, but it's really any disclosures. So where novelty is implicated, where there's only one disclosure, one invention that exists out in the world, obviousness allows the combination, and it's makes it more difficult, if you will, to try to get around an obviousness rejection that a patent examiner may have issued on your patent application, because you're fighting, what is the motivation to combine, or what brings about a person's desire to combine two or more elements. So what is non-obviousness? So an invention is, not suggested by prior art or a combination of prior art items to a person of skill in the art. Again, that's sort of our magic person here who would have the requisite knowledge consistent with the disclosure of the patent application. But we're talking about all kinds of things, not just other patents. Prior art can be other publications, other products. It can be disclosures, as Drew noted earlier, by yourself or by others. And it can be intentional or otherwise. So accidental disclosures or a test sale to a customer, that may implicate the on-sale bar. So in any instance, you've got prior art. It can be anything that sort of exists in the public purview that predates your patent application filing. So, we've gone through the sort of statutory elements of novelty, utility, and non-obviousness. Let's talk about the steps of once you've come up with an invention, how do you go file and get patent protection? So obviously you're starting with some conception. We like to describe it as eureka to put some emphasis on it, but at the end of the day, most of these inventions and eureka moments are incremental in nature, right? They're further improvements and advancements on technology that are already known or further being developed. And we see this not just in like the biochemical or genetic sphere, but in a lot of other technology spaces. So once we decide, yes, this is a great invention, we may do a patentability search to determine, yes, we've got something worthy of patent protection, and also sort of check the box on, we don't believe that this would be a good trade secret because it would be difficult to keep secret, right? So let's proceed with getting patent protection. Well, we're going to prepare and file an application. And that application has to be as we often describe it as patent attorneys, the complete manual and guide how to make and use the invention. It's got to have all the details. Once that's in the application, we file that application, and then it gets examined by the Patent and Trademark Office here in the US or in a patent and trademark office around the world. And we call it prosecution. So we're prosecuting the patent application. We're working with the patent examiner. We may interview the case with the examiner to try to get an allowance. And then ultimately, the patent application will issue. That's the high overview standard of the procedure. Let's dig in just a little bit because there's different types of applications. And if you walk in our door with an invention, there may be certain buckets that you would fit in better than others. So a provisional patent application is a early rough application that may not necessarily meet all the requirements of a standard patent application. So standard utility applications, which is the second bullet in this slide, is the real deal patent applications that we file that get examined by the patent office. Provisional patent application is one that doesn't have to have formal figures. It doesn't have to have formal claims. So the claims define sort of the meat and bounds of the invention, at least what the inventor considers to be their invention and what should be, excluded by any competitors or third parties. But provisional patent applications are a very, very useful tool, and we use them quite a bit. So they set a date on, the filing for basically a flag in the sand to draw a point to, this is where we invented this technology. The patent application has to have still a lot of the same written description, enablement, and requirements that fully disclose the invention, but it only buys the applicant a year. Within a year, you have to file a utility application that claims priority to the provisional. So it's more of a placeholder. But it's a valuable placeholder because in a lot of instances, we get technology that comes into our office and it's still really new and it's still yet to be refined, tested, or really, put into working order for either the client that is our client or their customers. And that year tends to buy our clients a good bit of time to do all that testing, to refine the invention. Wherein a year later, we file that utility application. It may look a little different than that provisional. It may have more meat on the bone and more details. And that's what gets examined, that utility application. So sometimes if there's, an early disclosure, and we work with a lot of universities as well. So we've got a professor that's racing off to give a speech, and he's going to publish a paper. We need to get something on file quickly. It's hard to get a good wholesome utility application on file. So we will file a provisional application and the inventor or professor, whoever, may go give their speech. And then later on, we have to essentially pick up the pieces and make sure we haven't missed anything. And we may file multiple provisional applications. There may be an instance where the professor's further doing, research and development and refining the invention. and is ready to give the next paper or the next talk, but it's not yet the year before the utility is due. So we work with clients a lot in what is otherwise a changing, R&D sphere that they work and live in, to try to best capture the inventions on the fly. And that year grace period for the provisionals is worth quite a bit, and we use it quite often. Setting aside provisional patent applications and then utility patent applications, there are others out there. So a design application is just that. It's covering an ornamental design. There's not the same utility requirements. It doesn't have all the same limitations. And frankly, it won't have the same body of written language and what we call the specification. It mainly relies on the figures and its unique ornamental designs. And then finally, plant patent applications cover just that, varietals of plants that are unique and then haven't existed prior in time. Obviously, for our ag bio clients, that's an important aspect of their portfolio protection. So moving back to the first application I mentioned, the provisional, it's never examined. And it's just a placeholder, as I mentioned, to get to the real application, what we call the utility application. So, most common verbiage that is used for, we're going to go get a patent, that's referring to a utility patent. That utility patent grows from often the seed that is the provisional that's filed. So once a provisional is filed, you can't claim priority to any other application. It sort of exists on its own. A foreign application can claim priority to a U.S. provisional, but a design application cannot. So usually, if we're in the world where we've got something that has utility and it belongs either in a provisional application or a utility application, it may also have its own unique designs. Well, at the time we file a utility, we may be filing a design application as well. So these are all things to consider, or at least things that we consider when we are looking at the inventions of our clients. I alluded to earlier about some of the requirements that are distinctive within the applications, and particularly within a provisional patent application. So we don't need drawings and we don't need claims. Again, claims are those specific legalese numbered paragraphs at the end of the patent that define the metes and bounds. So without figures and without claims, the bare minimum is some specification that complies with the code. This is 35 USC section 112, and a filing fee. Now, if drawings are necessary to understand the invention, then we would want to and will include figures. But beyond that, the cover sheet has the basic filing sort of elements of the inventor and the identification of the provisional application. And that's it. It's intended to be an easy exercise. It's $165 for a regular entity to file a provisional patent application. That's exceedingly cheap. And it's a cheap and easy method to get something on file. It may not be the best thing that we would like to normally file, but if we're on a short timeline, it's the best tool we've got. So I want to briefly talk about the importance of timelines, because timelines are critical in our world. We live and die by them. Our docketing calendars all the dates of upcoming applications and filings, and we have to constantly sort of double check those dates and confirm that we have all the necessary elements within our patent application. There's an old case, New Railroad versus Vermeer. It's a federal circuit case. So the federal circuit is the court of appeals that hears all patent appeals from the various district courts. But New Railroad owned a patent drawn to a drill bit for horizontal drilling in rock formations. And they sued a competitor, Vermeer, for infringement. Now, the interesting part about this invention is that this drill bit had sort of this angled sond housing that made it really, state of the art and unique. And that angle provided for quite the advancement in the technology over what was known in the prior art. So that was an interesting element. It was a part of Claim 1. It was an important piece of the invention. and it was critical to this case. So this is a picture, figure 4 of the patent, that shows that angle right there between 108 and 118. And you can see that that angle is disclosed at least in this 283 patent. And it becomes important because the patent itself properly claimed priority to a provisional patent application. And that patent application was filed for, about a year before the invention was on sale a year before the provisional application was filed. So ideally, in most situations, we want to see the actual device so that we're matching up the patent application to what the device is. Here, there was a device on sale for a year. You're still within the year grace period, so you think you're good. You've got a patent application on file, right? Unfortunately, the provisional application failed to disclose that angled sonde housing. It was absent from that disclosure. So that 1 year bar steps in for anything that was disclosed. And here, the sale, the actual public sale of the invention, caused the timeline beginning in 1996 to lapse a year later before the utility was filed, the third point on this timeline, in 1997. And therefore, there was no disclosure in that utility application of this angled sonde housing within a year of the public disclosure. And if there's no patent application on file within a year of that public disclosure, the patent's invalid. So the court found the true filing date was more than 1 year after the public disclosure, and it defeated the patent. So the patent's invalid. All of this effort that was gone into the R&D, the patent application filing, and I'm sure quite a bit of money to litigate this matter all the way to the federal circuit, all to end up with nothing. So these dates are critically important, and we pay close attention to them, and we work, quite frankly, very intrusively and invasively with our clients to make sure we've got every detail of the invention. And that takes a lot of hands-on work and experience. But patent application, as I've moved on to slide 41, has at both sort of the provisional stage, but really more importantly at the utility stage, these are the elements that have to be in the utility application. So the specification is the guts. It's the meat on the bone. It's all the detailed description, the summary, the background. It tells really the nuts and bolts of how to make and use the invention. Okay, and we like to include as many embodiments as possible. In fact, we like to work with clients to brainstorm and think about how they might design around their own inventions, so that if we can possibly include that in the patent application, we've got greater coverage than we otherwise would. And we can thwart, or at least better thwart, competition. The figures, there's particular requirements for the figures, including right down to the line thickness and drawings. We work with draftspeople that are experts in this field. But most importantly, and as Judge Rich said, the old judge on the, or one of the earliest judges on the federal circuit, that said, claims are king. Claims are the metes and bounds of the invention. They're the very legalese worded, numerical paragraphed ending of the patent that define what is and what is not the invention. It's what gets litigated. It's what is the basis of the negotiation with the patent office on how broad or narrow this invention is ultimately going to be claimed. And it determines ultimately how broad or narrow the copycats can get around this patent. So it's a very, very important piece, almost as important as the dates. So we've included a couple old examples, like Abraham Lincoln was an inventor for a vessel. We've got Harry Houdini was an inventor, another famous inventor of a diver suit. And of course, Eddie Van Halen, musical instrument support. It's one of my favorites. So there's quite a bit of fun, interesting things that come across our desk, and frankly, we get to see all the cool stuff before almost anyone else. But as I mentioned earlier, the term of the patent, the active term of the patent, where it is within the scope of being used to exclude others is 20 years from the filing date. Now, applications themselves, the patent applications don't even get published for 18 months until after filing. So even if we've got a new invention that comes in the door and we're assessing patentability, there's always a grace period of patent applications that we just won't see. And that grace period is 18 months. And there's reasoning behind that, both policy and statutorily, why there's an 18-month window. It also aligns with the treaties that we have with many other countries that afford the same time period for publication. But for our clients, say they file a provisional patent application. Say at the end of that period, they decide, you know, this would be better kept as a trade secret. We can still do that. As long as that patent application doesn't end up getting filed as a utility and then publishing within the 18-month total mark, it will remain confidential and private and never see the light of day. So again, another benefit of filing a provisional patent application, but there's certain benefits for that. And then finally, to keep the patents alive, there's maintenance fees that are due. And those maintenance fees come roughly every 4 years after issuance. And they scale up in what is owed quite a bit. So I think we're at our next polling question. Is that right?
We are. I can drive us through it. So another hypothetical here where your team has invented a new product conceived of multiple different embodiments that include a number of what the company believes will be commercially valuable and patentable features. What's the better option for your patent application? A full, robust disclosure that teaches each of the different embodiments? Or do you sit and hold the good ones back and keep them secret, even though you plan on commercializing them? We'll give everyone a chance to weigh in here. Couple more seconds, got a few folks still thinking about it. It's tricky. Just so everyone's excited, this is the end of patents and we're moving on to other stuff these last 10 minutes or so. All right, there's 4 of you out there sleeping. All right, you missed it. Here we go. 92% say a full, robust disclosure. I couldn't agree more. As Rick alluded to, you want to have as much in there as possible. That gives us as many hooks later to write claims and craft claims against even what a competitor's doing. And in fact, we are involved in cases on both sides where a full, robust disclosure has given the patent owner the ability to keep getting continuation patents written and additional claims issued that actually are written directly on the competing product they're trying to sell or trying to preclude from the market. So it can be a very powerful tool. All right. So as promised, we're going to move on to trademarks. Trademarks, you see them every day, but they still have a lot of nuance and IP vagaries to them. High level, a trademark, word, phrase, symbol, design, or combination thereof that identifies and distinguishes the source of good. Service mark is the exact same thing, except it's on a service. So a service provider's mark is a service mark. Mark on some goods is a trademark. They effectively mean the same thing under the law. At the end of the day, a trademark or a protectable trademark is anything that the relevant consumers associate with the source of goods or services. That's the bottom line. It can be the logo, it can be the name of the company, it can be the jingle, it could be a smell. All these things are protectable as trademarks. It can be trade dress, which is a whole nother issue. How the product looks, non-functional features of a product can be recognizable by consumers and associate in the mind of the consumer a single source for those goods. That can be protectable as a trademark. And we'll talk about all that. So building on that, they represent the goodwill of the company. So this is a source identifier. When the consumer sees the logo or hears the jingle, they recognize it with the company and associate it with the goodwill associated with that brand, or the bad will, frankly. But I hopefully you have good products and consumers are happy with what you're providing, and they see the company name or whatever the trademark is and think, ah, yes, I want that one because I know it's going to be high quality and the best of the bunch. And that's their whole purpose. You know, they go back a long, long time to the first trademarks associating certain goods with original craftspeople or whoever was trying to sell their goods and distinguish them from other potential copycats. Trademarks, like patents that we've been discussing more in depth, fall under the umbrella of intellectual property. We'll talk about these remaining flavors of intellectual property, but trademarks are one of them. It's an intangible property that affords an exclusive right. And I think we heard at the beginning, trademarks are very advantageous because they can last forever. As long as consumers recognize your logo or your name with you, it is a trademark that is protectable, and you can preclude others from using confusingly similar versions of it. Different kinds of trademarks beyond that, you have what are known as certification marks. These are associated with unions or associations. I was thinking like the gluten-free stamp you might see on food these days, or a vegan label. You know, these are certification marks that a recognized trade group has, you know, controls who gets to use those and stamp them on their products. Consumers recognize those marks and know what they mean. Same with a collective mark. The example is the ABA, American Bar Association mark that indicates membership, but it's not used by the members. It's a collective organization. And here are some good examples. We all know Coca-Cola, Campbell's Soup, you know, those are the names. Those each have very recognizable logos associated with them. The Coca-Cola bottle has trade dress associated with it that goes back a long time, that affords consumer recognition as well. You can have the Apple symbol. You could have them combined together like the Ford logo there. And as I mentioned, there's a bunch of other flavors. The NBC chimes, I always think about the ba-da-ba-ba-ba from McDonald's, you know, all those recognizable jingles, those are protectable trademarks. There are scents that can be protected. I think Play-Doh has protection on what the Play-Doh smells like. Certain perfumes, obviously this floral scented sewing thread example, all different flavors of what can be a trademark. This was one slide I wanted to dive a little bit deeper on because it's one of the most common misconceptions about trademark I encounter on a day-to-day basis. And that is how trademark rights kind of manifest. The moment you hang your logo outside and start selling goods, you have what are known as common law trademark rights. You have started using a mark on that date. Consumers have started associating it with you. Those are common law rights that manifest immediately. You do not have to file a trademark application. You do not have to register them. They just exist by virtue of you using a mark such that consumers start to associate it with you. All trademark rights are based on actual use of a mark that consumers see and associate with you. Of course, we know that you can file trademark applications. The United States Patent and Trademark Office registers these trademarks, but it's a registry of rights, and that's the big distinction here. When you file a trademark application, and especially an actual use application under Section 1A of the Lanham Act, to get very technical with it, all you're doing is registering publicly with the Trademark Office trademark rights that you already have established by virtue of your use. And it is a way to create constructive notice to the world that you are claiming rights in that mark. And there are statutory presumptions that can be afforded to those and many other advantages if you ever have to go assert your trademark rights against somebody. Lots of advantages to registering them and getting this broader protection. But at the end of the day, it's really just a list of people who are claiming trademark rights. And there's an examination that confirms, at least at an introductory level, whether those rights are in fact protectable and whether you can enforce them against others. The United States has a great option in that situation where your marketing team has come up with a new logo or a new brand or a new initiative that they're very excited about protecting, and they want to go ahead and file for a trademark application. Well, if you file under Section 1A, you haven't used the mark yet. It hadn't been exposed to your customers yet. No one's associating this new brand with you yet, so you don't have any actual use. There's a provision for that. It's called an intent to use application. So you can file what is basically the same application, but just say this is something we intend to use, and it gets examined and cleared by the Trademark Office and gets presented on the list and giving notice to people that you intend to use it. But you have a period of time after you file and after it gets approved to actually submit evidence that you're using the mark to convert it into an actual registration to get those rights. You know, so these are great for those little test initiatives that you want to run, come up with some new ideas, make sure you can protect them before you actually spend all the money to roll them out. So that's the big things that we talk about with different types of trademark applications and whether and when you need one. Also here we outline you can get trademark protection almost anywhere in the world. In the US, we recognize certain foreign registrations and foreign applications under what's known as Section 44. So these are foreign registrations and applications that get registered here by virtue of their existence in other countries, and you kind of extend them into the US. And then you can also do this under what's known as the Madrid Protocol, which is an international agreement where countries have come together to create a uniform filing system for what will be international marks. You have to be using the mark in those countries generally. So you need a reason to go get protection there, but there are different strategies for how you would file internationally and how to do it best strategically that you would discuss when you're looking to extend that protection. Here's the other big one we see a lot, and that a lot of marketing folks tend to confuse just because they don't deal with it every day. I told you get common law trademarks the moment you start using them, common law trademark rights. A great way to show the world that you consider your new brand to be protectable is to put a TM on it. That is a notice that you are asserting a trademark right in the name or the jingle or whatever you're using. And that's why you see the little TM on branding and logos and packaging and whatnot. It's a great thing to do until you get the registration. And then the second you get an actual registered trademark, you want the circle R, because it provides notice of not only are you asserting trademark rights, but I have registered my trademark rights, which gives me even more statutory presumptions and advantages and puts the world on notice. There are many advantages for litigation purposes and assertion purposes of having those notice things on there, giving notice to the world of your trademark rights. They give you advantages if you ever have to go assert them. But just know, don't use the circle R until you're registered, because that's basically trademark misuse and you can get in trouble for that. TM first, and the second it gets registered, be planning to go to the circle R. All right, very briefly, copyright law goes back to the Constitution again. There's the US Copyright Office has its own act. You're protecting writings, the expression of ideas. So it's writings, movies, dance choreography, a wide range of things are protectable as a protectable expression that's unique to an author. We won't do a deep dive on this, but just know that copy registration is very, very cheap and has great advantages if you need to assert your copyright. So if you have a writing or you have photographs that you've created or other protectable copywritten works, getting them registered, it's like $50. And by getting it registered before the acts of infringement, you open up the door to very significant statutory damages and even attorney's fees that you can avail yourselves to go enforce this. So this is particularly important for the kind of small independent creators. Great advantages to registering your copyrights. And then lastly, we've already touched on it a bit, there it is, trade secrets. Formulas, processes, compilations of information. In the practical world, you're thinking client lists, we're thinking internal strategies, business strategies, things you can keep secret. The Coca-Cola formula is a great one that keeps secret. The secret 11 herbs and spices at KFC. Things that aren't easy to reverse engineer can be great trade secrets. And what's great about them is, well, if maybe you can patent them and maybe you can get 20 years. If you can keep them secret, it can be yours forever. And WD-40 is a trade secret that's doing pretty well. Again, Coca-Cola, these are things that people have kept secret, black box things that you can't just buy and recreate easily. There can be some great reasons you'd want to keep them protected. But then also just the more business general information like the clients list and such. If you have people coming in, you want to have your non-disclosure agreements in place. You want to have policies for maintaining this stuff under lock and key and making sure that employees don't take it, don't share it, don't send it out via email to other people, that your labeling is confidential. All those things will help you if you ever needed to go assert it against somebody else. So mostly patents, but that was the high level IP overview. We'll give a minute for some Q&A, if any, but otherwise it's been a pleasure talking to you and we can wrap up. I'm not seeing any questions and knowing it's due for a break. Thank you for joining us. After the break, You're going to hear from Caitlin Poe and Lauren Fussell for our final session of the day titled Internal Investigations in a Sort of Post-Pandemic World. They'll be going live at 3:20, so you got about 9 minutes to break and stretch your legs before the end of the road here. Thanks again.